here's Camilla Belich.
Able to make a contribution in this part one, and I want to touch on clause 120, which is part of schedule 1, which is I understand the part that we're debating, and I understand hasn't been traversed fully yet by the committee. I have an amendment in relation to this, which is to ensure that when employment information is provided to a sponsor, that this is done in a way which is consistent with the Privacy Act. So that is, I think, a big concern with this bill, is the fact that this particular provision in relation to the transfer of information to a sponsor was, my recollection is that it came about after the public submissions were held. I could be, Minister's welcome to correct me on that, but it wasn't traversed in public submissions. It was something that was suggested late in the day. And we have concerns about this. And the reason that we have concerns about this particular provision is because essentially what this does is provide all the information that an employer holds on an employee. So, for example, if you think to jobs that you've had in the past and all the information you have had to give to your employer, for example, medical records, information about your family, when you've been sick, disciplinary matters, matters in relation to other personal information that might come about in your employment, those are usually all held on file by an employer. And this particular provision, obviously there would be an argument to say that on the conversion date of a state school, current school, that is not a charter school, into a charter school, that the person who becomes the employer as a sponsor would have a decent argument to say, well, I should have that information because that person's employment has transferred to me. Then that is obviously not necessarily something that I would disagree with. The thing that is objectionable, I think, under this particular legislation is the time period that this particular information is transferred to the new charter school. It's not on the conversion date. It is 3 months, it is either the conversion date or 3 months before the conversion date. 3 months before a conversion date is basically giving information which could be highly personal to someone who is a third party to your employment relationship and allowing them to have that information. Now, 3 months prior to a conversion of a school might be the exact period of time where someone who's employed by an existing state school that converts to a charter school may be considering, do I want to keep working here? Obviously, if we listen to the Minister, a charter school is innately different to the model that they would be working under. So they are having to consider, will they maintain their employment there? Will they go to another school? Will they try and find a job? They might not want their personal information to be held by a third party. I think there's a justification for it, as I said, on the conversion date, and that's why the amendment that I have put forward is to either transfer that information on the conversion date or require written permission from that particular person to allow that new employer as a sponsor at the charter school to have that information. I don't see any downside with this, because if you're unsure, if you think, well, possibly I might decide that I want to stay at the charter school, but I might also be looking for another job, you might say, okay, well, I'll let them have my employment file because a high probability is that I'll stay in this job and maybe I'll leave later, or maybe I'll see how it goes. So that, I think, would be a situation that might arise. The problem that we have here is that isn't what is included in the Act. We've had various concerns raised around privacy in this Act and also transparency in relation to the OIA, and I do know that there are concerns that members will want to address. I think the OIA part might be in part 2, but there are significant concerns that the Ombudsman raised around transparency. This is a privacy consideration. I don't think there has been time to consult with the Privacy Commissioner. I would be interested to know if the Minister has sought advice from the Privacy Commissioner on this point. I'd be interested to know if this was prima facie a breach of the Privacy Act, because essentially, if you look at the amended... Mr Chair.
Look, I appreciate the member engaging on this. I think what's important here is that this is employment-related information. So if we're committed to ensuring that the terms of employment are no less favourable, as I'm sure people are very interested in seeing happen, then you need to have employment-related information, and that means things like payroll and terms and conditions of their employment. And so I think the idea that this is going to be somebody's medical health records, that's misleading. That's not what we're suggesting. What we are suggesting is that the employment information should be. If you don't use this exclusion, then you are subject to the Privacy Act. So it's a narrow exemption from the Privacy Act for employment-related data that is useful for getting a person's terms and conditions right. I think I can understand the concern, but I think the member has exaggerated the risk here.
Camilla Belich.
Thank you to the Minister for his...
Okay, I think... Did he do a better job of answering that question?
Only just. Only just. But, I mean, at least he did answer the question, but I think he's left some major areas of concern, particularly around what charter schools will do with information. And I think really the big issue that wasn't really dealt with in that section, hopefully it will be dealt with later, is what happens with OIAs. Because I know that there's a lot of information that comes out in Official Information Act requests in relation to schools. I know that there's a lot of information that comes out, particularly in relation to OR's information requests. And if schools that are set up as charter schools are not going to be subject to the OAA, then I think that's really concerning. They're going to be off on their own. We don't know what they're doing. We don't know how they're spending their government funding, and we can't find any information about them. We're not allowed to ask through the OAA what they're up to. Sorry, Blake.
I'm
Go
not
ahead,
going to like this, guys, but I actually agree with David here. And I'll tell you why. Because for me, it's no different to 90-day trials. And then if they stay, they get to have the information the other way. So, for me, I quite like it because it's no different to 90-day trials. For me.
Well, and like also on that particular one, that would actually be disruptive when it comes to, say, students. Of like the fact, like, you know, I remember what it's like to have a change in teacher partway through the year or something like that. I remember how disruptive it was when one of the primary schools I went to, when because our former principal didn't do his job properly so we were technically classed as an overfunded school, and then all the teachers had to reapply for their jobs, and one teacher, because they reduced the number of positions available, that was actually quite disruptive when they had to change the way the whole class structure went. And I was one of those people who actually had to move classes midway through the year. It was not nice. It was something that, and I mean, I remember at college, not quite so bad, but I do remember, you know, different things there, like, you know, like at the start of the year, I remember we have a teacher, she got married. By term 2, she gave us the good news now she was pregnant to say that she is taking maternity leave for term 4. So it was quite an interesting year of how that went, and we had to get all our assessments done before the end of term 3, so that who was the reliever in term 4 didn't have to do any assessments.
Yeah, so not often I agree with David, but on this section of legislation, he's actually bang on the money.
Do you agree on that, Nick?
I don't tend to agree with David Seymour. It's not my general practice. So yeah, I think I'll leave that one.
Okay. Let's see how Camilla goes with more questions. These ones are a bit shorter.
Answers on that particular question. I would like to ask the Minister then whether he would be willing to support an amendment to specifically exclude medical and disciplinary information from the definition of employment information under this Act, for the purpose of making sure that the Act actually, or the bill, when it becomes an Act, actually does what he says it will do, and just provides information on payroll, and just provides information that the new sponsor would need to have, because anyone who's worked at a school, and we do have members present in the House who have done that, knows that employment information regularly includes the employee's personnel file, and that does include that information. So my question to the Minister is, if it is so narrow as he suggests that it is, will he accept an amendment to the Act to make sure that that information isn't passed on?
Mr. Chair, the short answer is no, because it's information, it's employment-related information that is relevant to employment. Now, the person might actually later be aggrieved that there are conditions of their employment that the new employer was not aware of because of the restriction the member proposes. So I can understand what she's trying to get at, but I suspect that by trying to have a bespoke definition of employment information in this legislation, she's liable to cause more harm than good.
Yeah.
Don't know how to take that one.
I mean, the problem with this is that we're trying to get definitions of information that are different within the current Employment Relations Act as to a definition that would be sitting outside of the Employment Relations Act within the charter school environment. And it just creates all sorts of difficulties when you have two different definitions applying to the same set of information, one within the public school setting, one within the charter school setting, and it just creates all sorts of difficulties. I think that's what Camilla was trying to say, that we need to have a common definition across all schooling environments so that everyone is clear. Say, for example, if a teacher moved across or if a teacher came back, then there was a common understanding. And I think what this has the potential to do is to create uncertainty about how information is treated. And I think that's where the concern lies around this one.
But you go first then.
I'm mentioning about something else in here. So this is not schools, but this shows what happens when you have a contradictory part of legislation. When it came to excise tax and alcohol, along with many other products, and this dates back pre-GST, you apply excise tax, duties, and all that after all other costs and margins have been taken into account. Mm-hmm. And then you put those taxes on top. Then we had GST come along that caused a contradiction in the law, in the excise tax one, where you apply GST on the final figure of the price. One particular winery in New Zealand was taking the definition and chose the customs excise tax was the final definition. So they were applying all their prices, applied the GST, then they add the excise tax on top of it. They got sprung by the IRD. They took the IRD to the High Court. The IRD won. That stated it was legal to put a tax on a tax. This, when you've got contradictory legislation, they tend to end up being settled in the court systems. And so the High Court may have to settle this if we have two sets of laws that are in place. So that is one that has been on there, and like people still to this day cry, it's a crime to have a tax on tax. They do that with petrol mainly is where they do it on. They don't tend to do it with alcohol. They don't tend to do it with cigarettes. They tend to do it with petrol and diesel. Okay, even that the reality land is if you sat there and took the GST off petrol, you changed the way it was made up, it would make businesses like mine a much harder job to sit and work out how to do our GST. It makes it harder for the IRD to audit us. You know, well, you keep this tax on a tax that seems to be unorthodox on. It's actually simpler overall for the system to function.
So let me just, sorry.
A similar point, they can point out what happens when you have contradictory laws. And that law still has been tidied up since that court case.
Let me just clarify. If this rule was to go through for charter schools, I would like it to be in public schools as well, because I don't see any problem with a school having access to the employee's medical information, because what if they, and I think about it from a safety point of view for the children, because what if they hire an older teacher and they've got a history of heart issues or something, you know, so that could prevent them from having a heart attack in the classroom. So this is why I like this section.
I think the issue is around the sharing of information, though. I think sharing of information is quite a complex area, and there's a whole lot of processes that need to happen in order for information to be shared. So certainly the Privacy Act has a lot of conditions that need to be met in order for information to be shared, and I think that's why the Privacy Commission needs to come in and do an assessment of this particular piece of proposed legislation in order to give their opinion on the privacy implications of this particular piece, because we are dealing with information sharing, and that's that is the proper process that when we are dealing with information sharing, the Privacy Commission is to give its opinion.
What I'm saying is, if I was a teacher, I wouldn't have a problem with this information being shared, because not that I would ever be able to anyway. So let's just say a person with cerebral palsy like myself could teach, right? It would then be on my record, oh, he has cerebral palsy, he has a history of fitting and all that. Then that would be a good piece of information to be shared. So that's why I like this, because especially for older teachers who are at risk of, heaven forbid, heart attack, at least they would know about it. So if it did happen, they would know, oh, he got a history of this issue, she got a history of that issue. And that's why I like it.
It would depend on the situation. I can tell you one thing here. I'm happy to talk to my GP about my health issues. I'm not happy to talk to, say, a work and income case manager about it. I wouldn't be happy to sit there and talk about my health issues with a tax auditor. I wouldn't want to be, I would be, depending on the relationship with my union rep, I'm not sure if I want to discuss some of that with my union rep necessarily. It can go in all sorts of different directions. Now this is more of where people can get the wrong end of the stick can be, is I have a dairy allergy. I've had flats turn me down because they thought I'd get an anaphylactic shock by resolving dairy. That doesn't happen with my allergy. It is about digestive system, and should we just say, the toilet is usually where I end up. But some people misunderstanding of things can lead to the wrong results as doing that. And often when something is misunderstood, it could be taken drastically out of proportion. Like I've had when it's come to looking at flats, where some people sit there and freak out over a dairy allergy. I mean, if we look at my current flat right now, I've got a dairy allergy, and my flatmate Clint has got a lactose allergy, which is a different allergy to dairy. A lot of people confuse the two together, and he has a gluten allergy. And I'd sit there and say, I have an idea of which of his family roots that came down. And I've got, we've got Brad who has no known allergies when it comes to dietary stuff. But it's like, how quick it would be to sit down there and actually, knowing what different allergies are for what. But when people, if people jump to conclusions when doing that, sometimes just that little sliver of information can lead to a drastic outcome. Rather, so that is where you've got to actually be careful. What you do there is not all information is good information. Sometimes you can have a perverse outcome over it. And that's where you need to sit there and actually work out what's the right information to have there, what's the wrong information to have there. Otherwise, you end up in a situation where wrong information goes out there. I mean, I had a whole rental property all fell to bits because the landlord decided Wings Over Wairarapa was a one-day event and sat there and issued me an ultimatum. He ended up losing a prospective tenant because he decided he knew things better than I did and got every single thing wrong. And, so these are the things there, sometimes too much information or slivers of information could provide perverse wrong outcomes. And that's what we're trying to avoid. Like anyone hears me sit there and say here, with work and income, you give them just the information they need. You give them too much information, they start making decisions that aren't right. And you spend a lot of time trying to fix up their mistakes that they'll keep trying to push through as the beneficiary is always wrong, even when the law says they're right.
I agree about the work and income, but
yeah, I mean, employers can get the wrong end of the stick. I do know what it's like to work for bad employers, and I can tell you right now, depending who you have in the management structure, can be the difference between a brilliantly run company and a company that could be crashing down there, or that can also be down to the schools. I also know that Paraparaumu College had a particular principal who came in there, should we just say, didn't really last that long as a principal and pretty much was shuffled away by the board. This is in a public school sector. It's quite funny. He's actually the principal at the school there. He used to be deputy principal at Wellington College now. So
yeah, I know there's pros and cons, but
and I think that's the point. That's what we're talking about. We're talking about employment information. That's what the the amendment to the bill is talking about. So I think there is a sensitivity around employment information, and if it does get into the wrong hands, it can have adverse impacts on people's future employment prospects. So I think that's why there is a bit of sensitivity around it.
And
So,
of course, we can agree to disagree, but I'm just letting you guys know how I particularly feel about this section, because that's what a show like this is for.
exactly.
Yeah.
Yep, that's all good.
Shall we see